Just read a brief profile about him. He is a PhD holder from Delhi University and currently is serving as a university librarian at Jamia Hamdard. And before joined Jamia Hamdard in July 2024, recently he has joined. Dr. Parvez was employed as university librarian at Maulana Azad National Urdu University as librarian and at Indian Institute of Management Indore. With a remarkable professional tenure spanning over 34 years, Dr. Parvez has accumulated diverse experience in both government and private sectors. His dedication to the field is evident in his 29 years long service in the capacity of librarian. Some of the noteworthy institutions where Dr. Parvez has contributed, that is National Council of Applied Economic Research, American Center, the India International Center, ICRA, IIM Indore, Maulana Azad National Urdu University. Dr. Parvez boasts an impressive publication record, having authored or edited 13 books and contributed to 20 papers in various journals and books. His expertise lies in designing process for different operations aspects of the library management and with a proven track record of enhancing staff efficiency through successful implementation. In addition to receiving prestigious awards in the field of library science, Dr. Parvez actively participates in significant roles such as serving on committees, panels, board of studies, and notably, he has played a pivotal role in establishing the HELP LIS Foundation, aims at supporting LIS professionals and their families severely affected by the COVID-19, showcasing his commitment to giving back to the LIS community. I think that's a good job for the social service Dr. Parvez has already started, and a lot of must have been benefited out of this. So really a great, you can say, academician, practicing librarian, plus a social reformer. And he is very much active on the even on the different platforms also. You must have seen in the conferences. MyLibnet is his brainchild, and most of the management libraries, whenever they hold the conference, you cannot imagine without Dr. Parvez, the management conferences is going on. So with these words, I invite you, Dr. Parvez, to speak to our audience. Although the number is 86, now I can see roughly 60 they have already joined, and others will be joining soon because the Bhaskar has left them just 5 minutes before. So it was a very interactive session, and they wanted to interact with him. I have to just cut the interaction short. So now it is your turn. You can interact with him. And the very interesting thing is, Dr. Akhtar will be speaking on digital content creation, technologies, copyright, licensing, and rights management. So that is a very interesting area. You all will enjoy it, listening to his experience and expertise. Over to you, Dr. Parvez.
Thank you, sir. Thank you very much, and thank you for inviting me for this session. And it is a great pleasure to be, in any of the programs conducted by your prestigious university. And I'm very happy that a lot of people attending this course at AMU. And I hope that my session will be of some use to the participants. So let me just share my screen with you. And just a second. So is my screen visible to you?
Yes, sir. Visible.
Yes,
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 sir.
sir.
Yes, sir. Visible.
Yes, sir.
Yes, sir.
Yes, sir. Yes, sir.
Okay, thank you very much. So as Professor Masoom Raza said that I recently joined this university in July 2024, and here we have started doing a few things which we hope that it will prove beneficial for our students, and we hopefully will make library a better place in the days to come. And let me also tell you, because Professor Masoom Raza was mentioning about the conference. So we will be organizing this MyLibnet conference here in Delhi at Jamia Hamdard in April 2025. So I invite you all to please come and attend the conference. And I'm very sure that you will have a great learning experience in this conference. So my topic is digital content creation technologies, copyright, licensing, and rights management. So technically, I'll be speaking more on copyright because this is one area where uh, librarians and faculty need more clarity. A lot of people come to us, especially the faculty, and they want to understand as to what is right and what is wrong when it comes to the use of making use of copyrighted material. So that is one reason, why we should be prepared with our answers. And I hope that I will be able to explain to you clearly. So I'll start with basics so that, I take everybody on board. I'm sure some of you may be aware of this concept quite well, but it's still for the benefit of all other participants. Let me just start it from the basic of intellectual property or copyright. So intellectual property is basically creations of the mind, and these creations could be like uh, you know we write books, we create designs, symbols, uh, we write articles, there are some artistic images, etc. So all those things come under creations of our minds, and the ambit of this definition is quite wide. Today I'm giving this lecture in front of you, so my lecture is also covered under intellectual property, and this is also intellectual property of mind. So when we talk of intellectual property, it covers, say, patents, copyright, trademarks, trade secrets, geographical indicators, which actually enable people to not only earn recognition, but also get some financial benefit out of our creations. And, when we say geographical indicators, you must have heard, names of Darjeeling tea, uh, etc. So by the name of the region, such things are known. And intellectual property is protected by law. And I'm sure you may be aware that on April 26th, we have World Intellectual Property Day. So let me start with the patent, what a patent is and what is the protection. So patent, as you may be aware, that it is an exclusive right which is granted to the creator for an invention and discoveries. And this cover ideas, devices, processes, methods, concepts, and machines. And if we see in India, the protection for uh, patent is 20 years. And basically, a patent provides owners with protection of their inventions. And that protection, as I said, is for 20 years in India. Now, trademark, if you go by the definition of Merriam-Webster's dictionary, it says a device such as a word pointing distinctly to the origin or ownership of merchandise to which it is applied and legally reserved to the exclusive use of the owner as maker or seller. So here, this exclusively reserved is very, very important. Now, these are some of the things, which you call them as trademarks. Um, because when we go to various stores, we see different things. So we immediately recognize, okay, this is Colgate. Then, on road, we see a lot of cars. This is Kia or this is Maruti. All those things, we recognize them more by their trademarks or logos, right? And then, the next thing is the trade secret. So what is trade secret? Trade secret basically are some secrets which provide competitive advantage to one company over the other company. Okay, because things like KFC. Everybody goes to KFC for eating chicken, etc. So they have a particular formula. So that formula they always keep secret because nobody else then knows about it. Similarly, if you have seen Pepsi or Coke or McDonald's burger, etc. So all these things, are prepared with a formula which these companies keep secret. So why they keep secret? Because these are the uh, valuable and commercial information for these companies. Okay. So, as I said in the beginning, that intellectual property is protected by law, and these are some of the laws that we currently have. One is the very important the Copyright Act of 1957. Then you have Patents Act. Then you have trademarks, designs, etc. All those things are there. Now, the question is, why do we need these laws? Okay, or why do we need that their creations should be protected? We invent a lot of things. On your screen, you see that there's a car, driverless car, which was manufactured by Google. And then, on the left hand side, you see COVID-19 vaccine. Then on the right hand side, you see some books. Then, the films. So, you know, we spend a lot of time, and in most of the cases, when obviously when this COVID vaccine was introduced, people must have invested a lot of money into these companies, especially. Also, the Google. So they invest a lot of money and they come out with the creations, okay, or the inventions. Similarly, we spend a lot of time, energy in writing books, films. Producers, they create cinemas, etc. So obviously, because we want to incentivize, we means, when I say, I mean the government actually wants to incentivize. Obviously, they will have to ensure that their creations are protected by some law. Otherwise, if there is no protection, say for example, if anybody is photocopying my book and selling it in the market, then next time probably I will not be incentivized to write books. Now, this is an image of Pathan movie, and it was pirated, I think, next after 2 or 3 days of the release. And because of the fact that I am a hardcore fan of Shah Rukh Khan, so I still went to the cinema and watched this movie. Similarly, this you see the Rais movie poster, and it was said that this became the most pirated Bollywood movie of 2017, and then followed by uh, other movies like Jolly LLB 2, etc. So there was a report in the Quaint which says Indian firms are losing $2.5 billion to piracy every year. So obviously, if the loss is so huge, then it will impact our economy. And because it impacts our economy, lots of employments are lost in the process. If movies are pirated, if books are photocopied, etc. So that is one reason, one very important reason, that obviously we want to, of course, strengthen economy. So these creations need some protection. So when we come to copyright, it is basically a type of intellectual property that protects creative works. Okay, and copyright protects the expression of an idea. Now, when I was telling you about patent, then even the idea is protected. Okay, but here it is very important that it has to be done in some expressionable format, whatever is protected under copyright. And apart from these, there has to be some originality. Okay, it should be unique. It should obviously be, should be some amount of creativity. And because of the fact, the creativity is the basic indicator for progress of any society or any country, right? Hence, it is very important that the creations of mind are protected by some law. And if you see section 14 of the Copyright Act, it says that copyright laws grants authors, artists, performers, producers of music, and other creators protection of their works. Okay, so you can read section 14 of the Copyright Act. So once again, anyone who contributes protectable expression is protected under the law. This term protectable expression is very important. Now there was a court case, where one company, not company, but an NGO went against other company, against people of India, and they said that they are copying our ideas. So the court said that an author cannot be granted copyright or exclusive rights over an idea itself. Copyright protects the specific expression or manifestation of ideas, not the ideas themselves. So this was the court ruling in case of Humans of Bombay versus people of India. So a lot of people say that it is a state created monopoly. What is a state created monopoly? I mean, if you are giving protection for 20 years and other number of years, so people say that it is a state created monopoly. But I feel that there has to be some balance between the rights of creators and public interest. So rights of creators are also important, and at the same time, public interest is also very important. And that is the reason that the protection is only for a limited number of, right? Not for endlessly. So, but as I said, for patents 20 years, for other copyright issues like say for example books, etc. It is lifetime of the author, then plus 60 years after the death of the author. This I will actually be talking more on this in my coming slides. So, this balance is very important, and these are the things which are covered under copyright. Books, poetry, movies, choreography, plays, softwares, images, photographs, sculptures, designs, etc. All these things are covered under copyright. So let me also briefly tell you about the history of the copyright, which started sometime, in the middle of 15th century. This idea emerged in England. And if you see the US, it was sometime, in late 15th century. And everyone wants to control publication. Everyone, when I say, I mean every government wants to control publications, every government wants to control media, and the same thing was there in England also. So what the king did, he appointed one government company, which was the only company which was responsible for publishing and printing. Okay, no other company was able to print or publish anything. So what this company used to do, they used to buy so they used to buy rights from the creator and publish. So if anyone else was publishing it, so there was some penalty. The copies were burnt and all those things were happening. And what happened, in 1610, you all know that we have Delivery of Books Act of 1954. So on the same lines, I'm not saying that they copied from us, but in 1600, in the same way, the company, that is Royal Company of Stationer, they got into an agreement with the Oxford University Library, and Mr. Thomas Bodley was librarian that time. It was in 1610. So they were supposed to deposit one copy of every publication in this library. So that is a brief, history internationally. And if you see these University of Oxford libraries, they are named as Bodleian libraries after Mr. Thomas Bodley. If you see the history in India, So the law of copyright was actually came into existence, in during British India, the British East India Company in 1847, and then in 1914, and now you see we have the Copyright Act of 1957. So after 1957, obviously, to accommodate newer things, you need to do amendments, and a lot of amendments were done in these years, starting from 83, and the latest, what I understand, is 21. I think after 21, there is no amendment, if I correctly remember, but you can always verify and check. So in 2012, there was a very important amendment with regard to the exceptions for libraries, exceptions for physically challenged people, and this I will explain to you in the next few slides. So the question is registering copyright mandatory or adding symbol C sufficient for protection under IPR laws? So even if you do not give this C within circle, there is no problem. Okay, your copyright is protected, right? You don't really need to register it. But if you put this C within circle, you all see that on the verso page, that is the back side of the title page, the C within circle is written either against the author or against the name of the publisher. So which means that there's a copyright, and the copyright belongs to either the author or publisher. So basically it is a prima facie evidence of ownership. So if I want some permission from for using a copyrighted material, then I should know whether I need to contact a particular author or I need to contact a publisher. So basically, it helps others to know who is the copyright holder. Now, let me also now, tell you what this Copyright Act of 1957 is. So basically, this stands for legal rights exclusively given to the authors or creators of the intellectual work. When I say exclusive, which means that it is given only to one single person. Okay, like sometimes we give the distributorship of our books only to one person. So that is the exclusive right. Okay. So copyright basically protects works of authorship, whether they are published or unpublished, but they should be in some tangible medium of expression, like films, maybe books, some computer software, etc. And because of the reason that in 1928 India became member of the Berne Convention, uh, and there are about 150 members of this Berne Convention. So our copyright is protected in all the countries which are members of the Berne Convention. US joined it quite late in 1988. So as I said, this is true for those individuals also which are who are in other countries. Say if somebody is in US, so his rights will be protected here in India because of this Berne Convention. So these are some of the important conventions which you may consider reading on the internet, and Berne Conventions, of course, very important. Now we come to the duration, as to what is the duration of the copyright. So if you see historically, the copyright duration was about 20 years, then it rose to 42 years. I'm talking about the total duration. Okay, then 52 years and so on and so forth. But now we see that today copyright sometimes can last for more than 100 years. Why? Because of the fact that the lifetime of the author and some number of years after the death of the author is calculated in ascertaining whether the copyright has expired or not, right? So in India, it is lifetime of the author and then plus 60 years. So basically, the copyright remains in force till the lifetime of the author and 60 years after the death of the author. And those 60 years are basically calendar years. And say if there are 2 authors or 3 authors, then the 60 years will start counting from the death of the last author. Okay, and I suggest you may read chapter 5 of the Copyright Act. And in case of anonymous or pseudonymous works, 60 years from the date of publications. So that is the copyright protection years. So I hope I am making some sense to you. If anybody has needs any clarity with regard to what I have spoken till now, you are free to ask me. You can free to interrupt me and ask. So I hope that I have made some sense. Now I come to the ownership of the copyright, right? As to who is the owner of the copyright. So author says that I am the owner of the copyright, but the employer says because of the fact that you did your work at the time during the period of your employment, so I am the copyright holder. Publisher says that, okay, look, you have transferred the right to me, so I am the copyright owner. State says that, okay, now because everything is produced here, so I become the owner. But as a librarian, we have to be really very, very careful in ensuring that all these copyrighted material are used properly. We are able to help our users by making proper use of all the copyrighted material under fair use mechanism. Okay, so this fair use mechanism concept is very important for us to understand, and I will be talking in detail about this fair use mechanism. So say if this is a document of the National Digital Library of India. So this work was given to these authors, Professor, Indranath Gupta and others. So they were asked to prepare this document. So because of the fact that National Digital Library of India asked them to produce it, so here NDLI was the copyright holder of this particular document. But when I write articles, when I write books, all those things during the period of my employment, those things are mine, which means I am the owner of those works. I am the creator of that work, and the copyright rests with me. Similarly, if you do some projects of some government agency, then it depends, what the agreement says. So if the agreement says that the copyright rests with the agency, obviously it will rest with the agency. Or if it says otherwise, then that will be followed. So the author, which is the creator of the work, and since he or she is the owner of the copyright or his creations, and artists of photographs, those people are basically the owners. So you can read section 17 of the Copyright Act to know more on this. So what are the rights of creators? So let us also understand what are the rights to reproduce the copyrighted work. So reproduce, I can, if I have a book, I can always, get them reprinted. I can distribute copies of my copyrighted material, whether it is in the class or I can sell it. I can rent it out. I can transfer the ownership to any publisher. I can, even convert my book chapter into a journal article. I can convert my novel or fiction or any book into a movie. So I can, convert my English language article into some other language article. So these things are called derivative works. Okay, converting things into different forms. And then, if, say, for example, if somebody is a dancer or a musician or performer, then they can perform their copyrighted works. They can display, like, you must have seen paintings are displayed. So as a copyright owner, people can display their paintings. And we can also, grant permission or licenses. And those permission or licenses could be either exclusive or non-exclusive. When I say exclusive, as I explained to you just a few minutes back, that only one person is authorized to do a particular job, like, for example, distributorship of my book. So what are non-exclusive license? Non-exclusive exclusive license, for our understanding, for the understanding of librarians, is that we subscribe to a lot of electronic resources, databases. So we get non-exclusive rights for using those content. We do not become the owners, but we only have the right to use those things, and those are non-exclusive rights. And those rights, basically, when we subscribe to something, are covered by the license agreement that we sign with the publishers. Okay, so let me also tell you the difference between, major differences, of course, between copyright violation or infringement and plagiarism. So copyright infringement is using someone else's work without obtaining their permission, and plagiarism means when you do not acknowledge. In case of copyright infringement, only affected party can lodge the complaint, which is not true when it comes to plagiarism. Copyright infringement cases are, always taken up by court of laws, whereas, if this is a plagiarism case, so now we follow the UGC regulation of 2018, where this departmental academic integrity panel or institutional academic integrity panel, they take a call on this. So the maximum punishment in case of copyright infringement is, either compensating the person uh, or imprisonment. Okay, but in case of plagiarism, the maximum punishment is maybe, in case of faculty or staff, you may be terminated, and for students, the registration of those students may be cancelled. The difference, one important difference in copyright infringement and plagiarism is that in case of plagiarism, the interpretation chances are very less or rare. But when it comes to the copyright infringement, then we see that we do not know how the court may interpret a particular thing. Now, and this I will explain to you with some case studies or the actual cases which happened in the past. So this lady is Vasundhara Das, who actually sang 9 stanzas of this Kajrare Kajrare song from Bunty Bubbly movie, and it was a Yash Raj film. So what happened as Yash Raj film went to the court and said that Vasundhara Das has actually infringed their copyright. And the court, when they were hearing the matter, they were contemplating what we should do, and they thought that possibly, it is copyright infringement. But at the same time, they also felt that if we treat this as copyright infringement, then what will happen to those cases where, in birthdays, people, in birthday parties, people sing a lot of songs. So it should not happen that the courts are flooded with the court cases. So the court said that, it is trivial violation. So basically, this case was not entertained by the honorable courts. Similarly, this is a very famous case of 2011, that is monkey selfie case. So this, I suggest you must read it on Wikipedia. It is given there. But let me just explain to you for your benefit. In 2011 and between 2011 and 18, a lot of disputes happened about the copyright status of this monkey as to who owns the copyright, because it was a selfie which was taken by the monkey, and the photographer or the camera was owned by one, David Slater. He was a British photographer. So what happened that this Wikimedia Commons and TechDirt, they put the selfie in their publications, but the Slater objected to it. He said that you cannot do that. But at the same time, there is another NGO called People for the Ethical Treatment of Animals. They said that the copyright should be assigned to monkey. And in the process, the photographer lost a lot of money. I mean, it was reported that, he lost £12,000 in 2021, and his business as a wildlife photographer affected severely. So when the court was listening to this case, the argument of the photographer was that he traveled to Indonesia, he befriended the animal. He created situations where the monkey was able to take selfies, and finally the court said that non entity, or I mean other than human beings, I mean this non-human creator cannot be assigned copyright. And they also actually doubted the intention of people for ethical treatment of animals, saying that their intention was probably to earn revenue and not the welfare of animals. So finally, the court ruled in favor of the photographer. And then, there was, I actually tried looking for this movie because I read a news that this was somebody took exclusive rights and wanted to create a movie of this particular case, but I could not really locate this on the internet. So if you do, please send me a link. I'm very interested to watch this. This is another very, important and painful case of Sharbat Gulash, who was, photographed by National Geographic in 1985. And, here the photographer and that time, the war was going on between Russians, I think, invaded Afghanistan. So basically, they wanted they said that, this war fear was reflecting from this girl's eyes, and they made a lot of money. And in fact, in one of the interviews of the to the CNN, the photographer said, the photographer name was Macquarie. He said that when I showed it to the editor of the National Geographic, he leaped to my feet and shouted that that's the next cover of the National Geographic. And they you will, I mean, it is very surprising, that the larger prints they sold for 1.5 crores each, and they made a lot of money. And in 2016, this Sharbat Gula was arrested because there was an interview done by this photographer Macquarie once again. And she said, though it brought fame to her, but then, it was very painful for her. She was arrested because she was staying unauthorizedly in Pakistan. So, though she was a citizen of Afghanistan. So, she was arrested. She was put behind bar for 15 days. And when, this photographer the photo was taken, the permission was not sought from her. That time also she was in burqa, but, she was convinced by someone to remove the burqa and show her face. So all those things happened. So a lot of people say that Macquarie, the photographer, used his position to do this, and he also misrepresented her because he was showing the fear of war in her eyes, but that was not true. And he actually violated her personal space. So a lot of people said that she was like unpaid model who was not given anything by the photographer, and it was unethical on the part of the photographer without taking the permission of either the person, because she was only 12 years, so he could have ideally taken the permission from the parents. Anyway, so this was a very interesting case, and this is another case. Now because of the AI, a lot of authors are suing Chat GPT and other companies which are into artificial intelligence. So they said that these two authors said that Chat GPT breached copyright law by training its model on novels without the permission of authors. And in the court, they brought this to the notice of the judges, and the prompt, they gave this prompt that summarize in detail the first paper of this book by this author, and immediately, it brought the summary of that. So the authors said that how can these AI use their content without their permission? So similarly, this New York Times went against, I think, Microsoft or something. So these cases are still going on in the US. So let us see what will be the outcome. We don't know. So coming back to, leaving these case studies, coming back to the copyright related issues, there are legal reasons and, of course, ethical reasons for following copyright. Okay, and in digital content, the copyright is, understanding copyright becomes more complex. So before I start telling you more on this aspect, let me just first explain to you what is digital rights management. And you all are librarians, you must be knowing this is popularly known as DRM, which basically is used to protect the intellectual property um, uh, uh, from misuse. Okay, so and DRM is all about access. When I say DRM is all about access, I mean to say that it controls as to who can access the content, right? So whether it is Netflix or whether it is in library database, so it first recognizes you, only then it allows you to use the content. Then what you can do with the content. Now when it comes to databases, can you download? If you can download, how much you can download? Can you print? Can you share? All those things come under DRM. And then when can the users access it? You see that on Tata Sky or on such platforms, the first movie come in the theaters, and after some months or years it is shown on the on Tata Sky or something. So that is called embargo. So that is about when can the user access. Similarly, what are the geographical restrictions? Can you use the same product which you are subscribed in India in the US? I don't think you cannot use it. Similarly, for how long you can use it, like for what is the subscription period. And that is the reason why I always say to the librarians that we should always try to purchase products which are no DRM products. Okay. Now, the most important thing which I must tell you, I think I have to. Your time is 12:15, so we will keep about 15-20 minutes or more for discussion. So I hope I'll finish it by 12 or before that. So this is the question I have for you. How do I decide about using any copyrighted material? But before we answer this question, I think it's important that we understand these five things. That is public domain. What are exceptions? What is the licensing? What are permissions? What is fair use? Okay. So let us first understand public domain. So if you go by definition, it says that public domain refers to creative works that are not protected under copyright and any other form of IPR laws. The public owns such works, not an individual creator. No permission is needed to use such works which are in the public domain and are not copyrighted. So is all the open access content can be said is public information or public domain information? May or may not, because again, in open access content, there are licenses, there are restrictions as to what you can do. It is not a copyright free content in most of the cases. So when we say that what is public domain information, the work falls under the public domain if the copyrighted term has expired, number one. The copyright owner puts his or own work in public domain. This is also called actually dedicated works. And then third is things which cannot be copyrighted, which are not copyrightable. Like for example, the short phrases, slogans, facts, ideas, titles of books. You see, there could be many books having the same title, like Fundamentals of Physics, but the authors may be different. So these things cannot be copyrighted. So that is one thing. I mean, I told you about the public domain. Now the next is the exceptions. So we have classroom exception, and then we have library exception also. So when it comes to classroom exceptions, face-to-face classroom exception has a lot of liberty. I mean, you can simply distribute copies of any article, copyrighted article in your class, if it is a physical class, but provided it is a not-for-profit organization. Your university should be, or your college should be, not-for-profit organization, which generally is actually like that only. Then the third is that when you take physical classes, make sure that students are sensitized that all these works have copyright licensing with them, and accordingly they should be used. So that is the classroom exception. Now physical classroom exception. When it comes to online or digital class, we must make sure that it is a close registered group of students. For example, today you have this class, so it is the responsibility of the EMU that only registered participants are part of this class. Okay, it should not happen that others are also part of this class. And as I said earlier also, that the amount of material which can be used in a physical classroom has all the exceptions, which may not be true in online classes. Okay, just a second. Just a second, please. Also, students must be sensitized. They should not interfere the DRM technology. So as a teacher, what you can consider is maybe, consider locking of files when you're giving a digital class delivery. You can consider streaming. You need to probably, have no download option. You can use low resolution pictures. You disable right click, etc. And when it comes to, of course, subscribe the resources in an online classroom, then the same thing will apply. What is the same thing? That what license you have signed with the publisher. Let me also now come to the other exception, which is library exception. So this library exception is applicable to all public libraries. When I say public libraries, I do not say the public library that we understand in our library science courses. When I say public libraries here, in case of copyright, it is those libraries which are not for profit libraries, including university libraries, college libraries, etc. So if you feel that a book is being damaged or can be damaged, then there's no problem in making 3 copies of that book. But when you make 3 copies, make sure that that book is not available in the market at a fair price. So what is that fair price? Fair price can be different for you, can be different for me. If I am working in university, then if the original cost of the book is 100 rupees, and if I go to the market to purchase or replace those copies, if it is 200 rupees, maybe I may not find it a fair price. And if you're working in an IM which have a lot of money, so if you go to any of the if you go to any market and you find that the replacement cost is 200, you may find it perfectly fine. So that actually depends on your judgment, as to what is the meaning of fair price. Now, the next exception, and this is, as I said, this was 2012 amendment. The Copyright Act said that there is no problem in storing all our library material into a digital format, but it says only storing. It does not say that you can distribute. When I say distribute, I mean if I putting those stored or digitized material on the internet, on intranet, of course, internet, no question. But even on intranet, I should not put. But at the same time, I feel that maybe I should not look into in such a conservative manner. So I feel that there is no problem, if this material, copyrighted material, we can provide access to our users within the library premises. Okay, not on internet. Okay, right. So then, as I said, the purpose here actually, is the purpose of digitization should be preservation and not distribution. We have a large amount of Urdu books in our library, and they are not yet, copyright free. But I have been, for the last couple of months, I've been thinking to digitize them, because I know that nobody will publish these books, and same may be true for other languages, right? So I am planning to digitize them, but then not, not for the purpose of distribution. Also, I had told you that there are exceptions for especially abled people or physically challenged people. So if there is a person who has sight deficiency, then there is no problem in giving him the speech format of the book. Now there are scanners which convert text into speech. So if it is given to a blind person, then or a person who has less sight, and then there is no problem. This copyright there is an exception. Now, the third thing is licensing, and I think as a librarians, we must understand it very carefully as to what is licensing when it comes to uh, copyright related issues. So it means basically the permission to use, or it is also called terms of service or terms of conditions or terms of use. And unlike print material, I said online content comes with huge restrictions. So accordingly, you have to use them. Say if I'm using an image from internet, say I like this particular image and I want to use it. So it's not that I just can use it. I must find out what is the copyright terms. So I went to Google Images. I found one image. I went to the next step, and then I uh, came to this particular step where it was written terms of use or privacy. So I went there, I saw, okay, now this is how I can use, this is the terms of use, and accordingly I used. Similarly, when you download images from Google Images, you must ensure that you see the tools, and the tools see, there are commercial images, there are Creative Commons license images. So maybe you can consider Creative Commons license images, which has liberal licensing policy. Flickr, I find, is a very good site for images. I find better images in Flickr than Google Images. Similarly, if you want to use some clip of a video, maybe you can consider using those videos which have Creative Commons licenses. And these are the Creative Commons licenses. You all are librarians. I am very sure you know what Creative Commons licenses are. But if you do not know, please go to this website and you will know what this creative. Just type in Creative Commons licenses, and then you will get all the information. And there is one license chooser also. So if I'm not sure, I generally when I create whatever videos I have created, I have put them under Creative Commons licenses. And if you are not sure as to what should be my license, then there is a page on Creative Commons licenses website, which by going there, you can simply choose a license by giving your answers to some of the questions. So now we come to another important aspect of licensing, that is license agreement, which we find in our libraries. So it is extremely important for every librarian, and when I say librarian, I say every library science professional, that we must understand the licensing agreements, which we must understand the terms of use. We do not really need to be a legal expert in this matter, but we must understand what licensing agreement is, because it affects our users. So in some of the cases, I must find out as to what is the definition of users. So when I was at IIM Indore, or my previous organization, Maulana Azad National Urdu University, we were to sign an agreement, and they said that the publisher said that the user means the students and faculty. But we said that users could also be those people who visit our institute, who come for attending conferences, etc. So the term was changed. We must see whether a particular product which we are buying has DRM, or it is no DRM product. We must find out, if there is a platform fee after a particular number of years. I tell you one very important uh, incident. There was a publisher who told us we wanted to buy some ebooks. So he said, and we wanted that the books should have perpetual access. So when I was reading, he said that the license is perpetual. So when I started reading the licensing agreement, I found that it was given that this perpetual license is for 15 years, and then we have to pay some charges annually. So for me as a librarian, perpetual means unlimited number of years. Okay, and I told them that we cannot purchase these books because these are not perpetual access. So he tried to convince us that it is perpetual, but then finally we did not buy. But next year, when we again started our purchases, so he changed the licensing agreement, and make it for an unlimited, made it for unlimited number of years. Similarly, whether you can use digital course packs in your, maybe whether you can download something and put in your digital course pack. I mean, all those things, we must inquire, we must see in the licensing agreement. And we also must see what happens if a journal is discontinued by a publisher. Is that journal, does that journal go to clogs or logs? I think these are very important issues which every librarian must see when it comes to electronic resources. Now I come to the permission part. What is permission? So permission is basically, first we must identify who owns the permission, who owns the work. Only then I can ask his or her permission for using that copyrighted material. I must send a formal request, and I must keep those permissions safe. As I said, sometimes, it is the copyright remains in force for more than 100 years. So it is my duty to identify the owner. It is my duty to get the permission, etc. But sometimes you don't get permission. Sometimes you do not find as to who has the copyright of that particular work. So the next is, fair use. So fair use is basically a mechanism which it's a legal term or doctrine which allows you to use a small amount of content under fair use mechanism. So this, we will discuss. This I used to get a lot of letters from Indian Reprographic Rights Organization, and they said that you can make this percentage. I think this is all, and they say that I mean, in those days they used to say that they are MHRD organization. So, I really don't need to go for membership of Indian Reprographic Rights Organization as long as I know what is copyright and how much content I can use. So now, since we have understood these 5 things, to some extent, let me put that question before you once again, that as to how I decide about using any copyrighted material. Okay, so these are 6 things which I have listed out here. First and foremost, obviously, I'll have to ascertain whether the work is copyrighted or not. So if it is not copyrighted, there's no problem. But if it is copyrighted, then I must find out if there is any exception given in the Copyright Act under which I can use the copyrighted material. Say, for example, if there is no such exception, then I can think of checking as to what does the license of that particular work says. Is it just that I acknowledge it and use it, or it needs some permission? Then, say for example, if the license also does not allow me to use that copyrighted work, I can consider using that copyrighted material under fair use mechanism. Assuming that I do not see this under fair use mechanism, then I must find out if who has the copyright of that particular work, and whether I can get the permission, and I try to get the permission. But in case you don't get the permission, then once again you can try or explore the possibility of using that copyrighted material under fair use mechanism. But the question is, what is fair use? Okay, so this is I got it from Columbia University website, where there were 4 checklist, 4 parameters were given. That is purpose of use, nature of material being used, amount of use, and impact or effect of use. So if the purpose, it says purpose of use, so it favors fair use and it opposes fair use. So if it is research, teaching, scholarship, it is not. If it is not-for-profit organization or institution, if the purpose is commenting on something, if criticism is the purpose, if news reporting is the purpose, then there is no problem. It favors fair use. But if it is commercial activity, if the purpose is entertainment, then it opposes fair use. For example, I show a movie in my class to all the students. So, which is a copyrighted movie. So there is no problem. But if I start showing that movie with my friends, then for the purpose of entertainment, then it is not fair use. It opposes fair use. Similarly, if you see this nature of material being used, if it is published work, no problem. If the information is factual or non-fiction based, then there is no problem. But if it is highly creative work, say for example some films or plays or novels, then it obviously does not favor fair use. Okay. Also, the third is amount of use. If the amount of use is small, then there's no problem. If the amount of use is large, then there is a problem. It does not favor fair use. Okay. Now, also there's a possibility that the amount of use could be small, but if I use that amount of uh, content from, say, from fiction, etc., which may be a central theme of that fiction, then again it may not favor fair use. Now, the last one is impact of use. So, if the impact is that there's no commercial impact on the person who owns the copyright, then there's no problem. But if it affects the copyright owner commercially, then there is a problem. So, these, if we see all these things, then there's no problem. Say, for example, if I have a book in my library, so we start, if I make 3 copies, then there is no problem. But if I make more copies, then there is a problem. Okay. So I think uh, such differences when it comes to in the context of fair use, we must understand. Now, this is a very important case, which you all know, the Delhi High Court case, which actually changed the complete definition of fair use in the context of amount of use. What I said, if the amount is small, there's no problem. But in the Delhi High Court judgment, they did not even, uh, you know, uh, mind people making a more number of pages as photocopy. And this case, I am sure, as a librarians, you may be aware that some publishers went against Rameshwari photocopy in 2012, and they said that this Rameshwari photocopy is basically infringing the copyrights by photocopying their publications and reproduction and distribution of copies among students, etc. The court felt that this ours is a developing country. People generally are poor here. Libraries cannot afford to buy as many copies as the number of students, and they actually decided in favor of the uh, Rameshwari photocopy. They allowed Rameshwari photocopying to keep photocopying books, and then in 2017 or so, the publisher went to the higher court. But after some time, they withdrew their case, and they said that we do not want to get into any confrontation or legal battle with the university or with the stakeholders. And for a brief period, these publishers, I think for 1 year, if I correctly remember, they stopped giving their publications to University of Delhi. And there was a very interesting editorial which was published in the Indian Express, which said that ruling in Delhi University copyright case reflects the inability of Indian courts to integrate legal outcomes with robust business models. And this is a 2016 editorial. And I really like this editorial because I also feel that probably the court did not, think about the business models. But at the same time, I'm not that I'm against the open access movement, etc. But then I think the creator also has some rights, and if those rights are snatched away from them, possibly the problem will be of lack of such works in the future. So yeah, and I also said that every case may have different interpretation. Every judge may have different interpretation. So we should not consider this as a license to make photocopies of books. I still remember, when this case came, I was working with IIM Indore, and that time one of the private colleges, they started photocopying all the books and started distributing to the students. But I am very sure that if the publisher goes to the court, probably the situation may be different. But as of now, that judgment is applicable, because after that there is no court case or judgment after this. Now, in one of the slides, I have also mentioned transformative use. I said that the fair use also favors when the use is transformative. Now, what is transformative use? Transformative use is that use when something is little improved and uh, 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 given to the user for their convenience. Now, the best example is, say, Clear Trip. Okay. Now, the Clear Trip, you go to Clear Trip's website, you find the prices of all the airlines. So instead of going to different pages of the airlines, you are finding all this information at one place. So this is transformative use. Also, this InCat, say, assuming that Inflibinet needed permission from us, okay, for hosting our catalog, even then it was transformative use, right? There was a case of Hathi Trust, so that they won the case because the court found that what Hathi Trust is doing is basically they are collating information from different places. They are putting digitized books at one place and putting it for the use of the readers. So they said it is transformative. There is no problem. Also, uh, there was a case, where it was said that publishers are taking the internet to court, and in this case, during COVID time, HarperCollins actually went to the court against Internet Archive because they had opened one national emergency library, and finally, because after the court order, they had to close this national emergency library. So this, I'm sure, this you all know. This again, in the court, so we don't know what will happen. So yes, so I think while concluding, I will say that we must understand fair use well. We must use the fine prints of agreements before using such copyrighted material. We must keep permission safe. We must respect IPR as librarians. We must, encourage people, and ourselves also, we must write in open access platforms with having liberal licensing policy and so on. So thank you very much, and I will be very happy if there are questions from your side. Let me just a second. Yes, please. So if there are any question, I will be very happy to take up those questions. Are you all there?
Yes, sir. Yes, sir.
Sir.
Okay. So there was
Yes,
a
sir.
bit of silence, so I thought maybe
Sir,
I am.
like
Yes.
one, two books are there in my library, and then my students' background are also not that very economically
sir.
sound. So in that case, if I scan the book and give in the WhatsApp group, is it infringement?
Yes, it is. It is distribution when you are sending something in a group. Now, what happens? What I see, and there was again, I think the Times of India went to the court during COVID. What happened that, and you will still see it, that a lot of people, they send complete PDF of the newspapers and magazines in WhatsApp groups. I think that's not right, because you are actually infringing copyright of the organization or the person. So what you can do is, if you send it only to one person, that is better, because if you send it in the group, that will be termed as distribution, and distribution is not allowed when it comes to Copyright Act.
What about the particular chapters or topic? If I give that one.
Yeah, I mean, there's no problem because again, when I was explaining fair use, so it will be under fair use. It is the purpose is teaching and learning, so there is no problem. Uh, but if it is the whole book, then there's a problem. So basically, you are replacing the book, and it will commercially impact the author who has written that book. So I think there's no problem in sending them one chapter or so. There's no problem if even if the entire uh, book is given to one person. Because why I'm saying this? I'm saying this on the basis of the copyright case judgment of the Delhi High Court. But then, to be on the safer side, I suggest that we must avoid sending things in group. Okay, so like for example, when we subscribe to some database, okay, so some faculty can download a book because we have subscription, so we can send it to all the students. But then I always suggest to faculty that maybe they should send the link, because the students also have access to that resource, so they can send a link to the students instead of sending the whole book. And in my university, what I did was, in my previous organization, which I will do here also. Let me just go to the website, and then I will show you what we did there. uh, just a second, uh, let me just yeah, in the meantime, I yeah, hope I'm clear, Sangeeta madam.
Sir.
Yes, please. Any other question?
Hello, sir. This is Kohila.
Yes, madam, how are you?
Fine, sir.
Yes,
So thank
please.
you very much, sir, for a nice presentation. I have only one query, sir. Suppose if the creation is done by two or more authors, who is the owner? So in the slide, it is mentioned it is under section 17. Please clarify that.
So you are saying if the work is owned by two or three authors,
Two
then
or three authors, who is the owner of the creation?
oh, okay, good question, madam.
Thank you, sir.
Okay, but let me just first show you. Okay, it's not yet open. Okay, so Dr. Kohila's question is that if there are more authors, what will happen? Who will be the owner? So if I am writing I'm writing a book with Dr. Kohila, so obviously we both of us are authors. But say for example, in the contribution of Dr. Kohila was more than me, and the contribution of mine was just that I wrote one page. Okay, so in the absence of any agreement between me and Dr. Kohila, both will be equal owners of the copyright works. But in such cases, it is always advisable that you say if both of us are the authors and Dr. Kohila has 99% of the contribution. So if the royalty is generated, I can always claim that I am also the rightful owner of the work, and I should also get the royalty. And Dr. Kohila will have to give me the royalty. But in case she had signed an agreement with me saying that I will have no right over the loyalty or any other revenue, etc., then the situation will be different. So I think if you have equal contribution, there is no problem. But if the contributions are not equal, it is better that we have some agreement in place, so that things are completely transparent and clear. Could I answer your question, Dr. Kohila?
Yes, sir. Thank you, sir.
Most welcome. Yeah, any other question, please? So,
Good afternoon, sir. I have a question.
yes, sir. Yes, sir.
This is Sufyan Ahmad from Jamia Millia Islamia.
सुफियान
Suppose
साहब
I have.
जी 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 खैरियत है सर.
Good afternoon, sir. Yes,
गुड
yes.
आफ्टरनून सर. गुड आफ्टरनून. बताइए बताइए.
So my question is, if I have to take some permission from the author, and if the author are more than one, so do I need to take permission from all of them, or the primary author who has created the work So
It depends. Actually, it depends who owns the copyright. Say if all the three owns. Say for example, if I have a book in your collaboration, and somebody asks me for the permission, and if I have an agreement with you that I am the owner, then I can give the permission. But if there is no agreement between us, then then a person will have to take permission from both of us.
okay, sir. Thank you very much.
Most welcome.
And
Yes,
thank you
please.
very much, sir, for your very informative and engaging lecture.
Thank you. Thank you very much. I try my level best always to be of some use to our friends or
Thanks, sir.
students. Yes. Any other question? I think instead of appreciating my article, giving this clapping, etc., I'll be happy if you ask questions. Because the reason why I stopped at just 5 to 12 was that there are more questions. So, which means that I really delivered my lecture quite well, and you don't have many questions. So that is what I can safely assume. But I'll be happy really that I am still giving you some time. If you have some question, please ask me. Or maybe you all are very learned that you know copyright quite well. Let me just.
Sir,
Ji, Sufyan,
sir, one more question.
Ji, sir,
In libraries, we find that users come and they request for photocopying of the book. So when we deny to go for the whole book at once, they get it issued and they do certain
Yes.
part of photocopying, and then again they issue it and they go for the rest of the pages. So in that case, what a
No,
librarian should do?
I think
What is your advice?
I think student is not intelligent that way. Now, what I do, if I am a
Yes.
student, I'll borrow a book and photocopy the whole book instead of doing it in chapters. Number one. Number two, when students come to me, if they want photocopy in the library of the whole book, I refuse. So the student says, ask me, can I get this book issued and get it photocopied outside? I said, I'm not aware of that. I don't know. Whatever you do, it is up to you. At least I am not. Actually, I want to help the student, right? So
Yes, yes.
even if I tell him कि भाई बाहर फोटोकॉपी मत करना, तो क्या वो मेरी बात सुनेगा? वो तो बाहर फिर भी कर सकता है. और अभी जो जजमेंट है वो जो दिल्ली हाई कोर्ट का, उसमें तो वो अलाउ करता है, ठीक है ना? तो उसमें वो कर सकते हैं. And secondly, it is if when we were seeing this fair use mechanism, so there it was, if it is for learning and teaching purpose, then there's no problem. So that will also apply to such kind of.
So as a librarian, if some book is not allowed for borrowing, if it is not allowed, and if it is reference material, how they to get the photocopy the whole book at once?
No, I think it should be decided on case-to-case basis. Say, for example, a faculty comes and he says that he wants this particular in reference book. Number one is nobody usually gets the whole book photocopy, because in a reference book we look for particular section. So whether it is some encyclopedia or something. So I think giving photocopy even of reference books, I think there should not be any problem. Now you see there are a large number of books which are available on the internet. The full text are available. So I think in today's time, the internet time, or when the all the information is getting digitized, I think being very conservative is not good. But yes, we must ensure we must ensure that we do not get into any legal issues.
Yes.
वो हमें बस देखना है, बाकी सब तो मेरे ख्याल से करने में कोई बात नहीं है, लेकिन लीगल इश्यूज हमें जरूर देखने चाहिए.
Sir, I have one question.
Yes, madam.
Sir, only for my knowledge sake, like there are a number of projects like NDLI and Project Gutenberg. They are providing the digitized documents,
Yes.
complete documents. So they have also taken the permissions from the authors and publishers, or how they do that?
Yes, yes. Very good question, madam. Very good, excellent question. Now, what happened, if you remember, earlier National Digital Library started long back. Not this one. That was, I think, National Digital Library. That was only National Digital Library, and a lot of content was digitized. Okay. The coffee they made. So lot of documents were digitized, but then some people went to the court saying that all those things that they have digitized actually is copyrighted material, and then finally, that site was closed. Okay, so if on Project Gutenberg, what I understand that on NDLI, everything is copyright free, and wherever things are copyright material, they have given the links. Okay, so, and also for Project Gutenberg, even for this what is that, Hathi Trust. So all these things, they are all copyright free books, but there could be a possibility that those books are not free from copyright. So what we have to do, I mean, in good faith, they have uploaded. Now, if I show you my this once again, resource. I'll answer you, but I wanted to show you e-resources guidelines, e-resources usage guideline at Manu website. We have given this. One second. I think this. Yeah. So what we have done is, the screen is visible to you?
No, sir, not yet.
Okay. I'm so sorry. Now I think you can see, right?
Yes, sir, it's visible now.
So हमने क्या किया है कि हमने ये देखिए बड़ा एक, ये मैंने कहाँ से लिया था मुझे याद नहीं आ रहा, कुछ मैंने यहाँ शायद दिया होगा. तो हमने ये एक फैकल्टी के लिए बड़ा चीज जो है वो यहाँ पर लिख दी है. ठीक है. What happens if the license is violated, conditions and use of license restrictions. So अब इसमें मैंने देखिए सोर्स भी लिखा हुआ है. Except minor changes in this document, all the content has been taken from InfluNet Center website. Okay, so
Right.
we had made some changes in it and we put it. Now, similarly, if I show you the repository of Jamia Hamdard, what we say that the library is committed to ensure all the university's resources are consolidated and one single providing user with access to these. The primary objective is to preserve community. Okay, so I think not here, but I think in my previous university, we had given the one disclaimer that we try that everything is copyright free, but if still there is something, please bring it to the knowledge of the librarian at this email ID. So coming back to your question, I think we have these books which are there. I mean, these are responsible agencies. So I'm sure that they do not put anything which are copyrighted.
Okay, sir. So can we download the documents from these websites like NDLI and the similar
Definitely,
websites
yes.
and put it on our website so that our users can use it, our students can use it?
Okay, there could be an issue with that because, say, for example, if I give some data to NDLI, okay, so I am giving that data to NDLI only. I am not giving it to you. So why not? How many books you download, right? So why you want to unnecessarily waste these space of your server, what you can do is you can give links of those resources. You can give the name of the book and link it to that resource rather than downloading, making all the efforts. So that
Okay,
is
sir.
an easier way of managing electronic resources. There are lakhs of digital records. So how long you will do this? I think that should be avoided at any cost. Now, what we do, again, if you go to our Manu's website, what we do there, that in our repository, for thesis, we simply give link of the Shodh Ganga rather than putting the thesis on our server once again.
Okay, sir.
Yes.
Right, sir. Thank you so much, sir.
Welcome, madam. Okay, so I am so happy that you asked so many questions, and I hope there are no other questions. So if you still have any doubt, you are welcome to write to me at my email ID akhtaronline@gmail.com, or you can call me. My numbers are there on our website. So somebody saying, sir, I'm downloading full books from Internet Archive. Is it under copyright? Okay, so it is very difficult to say as to which book actually you are talking about. So the responsibility is yours. If you are downloading a book and putting it to your server, then it is your responsibility. So Ranita Dash madam, why don't you simply give the link? That is the best way to let us not get into any kind of legal issues. The best issue will be that you simply give the link of that book rather than downloading. Now you are making a lot of effort in downloading. Why you want to make it? Okay. So thank you very much, and I really had a nice time with all of you, and we hope that we will meet again. Thank you.
Thank you, sir.
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 Thank you.
Thank
Behalf
you.
of the all participants, thank you, sir, very much. Akhtar, sir, thank you.
Thank you, sir.
Thank you, sir.
Thank you, Vijay Saab. Thank you, Vijay Saab. Thank you, everyone. Okay, bye-bye. I am
Thank you,
just
sir.
signing off.